We always start these out just by asking each candidate to tell us, first of all, why they're running for this particular office and what the case is for the voters to choose them on November 6th. So, John, we'll start with you if you don't mind.
All right, thank you. Thank you very much for having us. Why I'm running? Opportunity. It's an opportunity for continued public service. It's an opportunity to serve the public, as I said, and to bring to bear the knowledge and things I have learned in my legal career to help the community. Judges are public servants. I've said it 100 times. We work for the people. They don't work for us. And I have, over my career as the state's attorney, as a prosecutor, and as a judge, as 2 years as a judge, developed skills and talents that I can bring to the position. I was thinking about it like this. I think we would all agree the first story we wrote when we came to a paper probably wasn't our best story. The last one we write will probably be one of our best stories because you learn and acquire knowledge over that time, and it's my opportunity to apply that to this job. So that's why.
Tim?
Well, first and foremost, I think it's because I think I can do a good job. I think I have the type of experience that not only the length of that experience, but the variety and breadth of that experience. I'm confident that I can handle the job and do a very good job for the citizens of this area. Also, I think people ought to have a choice in who they elect to office. You know, I guess my slogan would be that I think people ought to be allowed to vote for who they choose and not who has been chosen for them. And I see it as a challenge. You know, I've been a lawyer now for 30 years. I've enjoyed that practice of law. I've enjoyed the clients that I've represented. I have 30 years experience as a prosecutor. I have 7 years experience as a city judge or a hearing officer for the city. But most importantly, I have experience in civil litigation, and that is courtroom experience and representing a great many people throughout this area in a very wide variety of cases. I have experience in the type of complex civil litigation that I think few lawyers in this area have. And I echo John's sentiment that, you know, sitting on the bench does help give you the type of experience that will enable you to be a better judge the longer you're there. But I think judge is a unique position in that it also helps to have experience as a litigator. If you understand what the lawyers are attempting to do with the law, if you understand the advantages they're seeking and the disadvantages that their opponent will suffer, you're able to do a better job and to handle the type of complex litigation that often is brought before the court. And so those are the reasons that I'm running.
Tim, I think this is more of a question for you, and John can respond, of course, afterwards. But, you know, in this case, they have an incumbent, although he was appointed. Why should the voters take a look at you and decide, well, Tim will do a better job than John? I mean, what's the case for them picking you over him?
Well, again, I think it's experience. You know, I understand, you know, that John has 20 years experience as a prosecutor. And you know, perhaps some of that responsibility involves civil litigation, but I think we're comparing apples and oranges there. The type of civil experience that I'm making reference to is actual trial experience, where you're in the courtroom litigating cases of a very complex and involved nature. And having that experience, I think, is quite unique. I take on professional negligence cases. I've taken on products liability cases against large corporate entities where, you know, you have multiple lawyers involved, and you're developing, I guess you first have to understand that there's a drastic difference between civil and criminal law. And unless you're a lawyer, it's kind of difficult to understand all the nuances of how those two areas operate. They're significantly different, however, and the rules of law that apply really are completely different. And one is the advantage of discovery. You know, that's where you're really getting involved in a civil litigation process. You're trying to prohibit the other side from introducing evidence that you think is irrelevant and you're trying to get your evidence in. And there's a lot of gamesmanship that goes into that. There's a lot of argument that goes into that. The whole crux of the matter is trying to handle the evidence that's put before the trier of fact so that your side can be a success. So what you're doing is you're being an advocate for your side. It's basically two boxers in a ring, and you're doing the best you can as an attorney. And being in that position, you understand the gamesmanship behind that. And you're able to, I think, not only understand the law, but how each side benefits. So that and the fact that, we're looking at 6 circuit judges over there right now. 5 of them are products of the state's attorney's office. One is I think she used to work for the state in some capacity. So none of them have the type of civil experience that I think I enjoy. And I believe not only could I be a better judge, but I could also make the bench, a better group of lawyers or group of judges, because I would be someone that they could come to and bounce ideas off and help explain where the other litigants are coming from on certain matters. So,
if I could interrupt for what percentage of a judge's cases in Sangamon County will be civil versus criminal? Do you have any idea what the breakdown is?
I believe the majority is civil.
Okay. John, is that right?
Probably a majority, close majority is civil. I have a very healthy criminal docket, a healthy civil docket, a very healthy probate docket, and a solo miscellaneous remedy docket. Every miscellaneous remedy case currently filed in Sangamon County by the computer, this is assigned by the computer, by the way, is assigned to me. So certainly the civil side will outnumber the criminal side because there's so many different types of civil cases.
How about your level of experience in the same,
Well, when you try cases, I think my trial experience speaks for itself. I've tried many, many cases. And the rules of evidence in a civil case and in a criminal case are absolutely the same. Hearsay in a civil case is hearsay in a criminal case. And you have to know it when you see it, or pardon the pun, hear it, to understand when an objection is proper and it's not. I have vast trial experience. I mean, I'm not, just look at the archives. I couldn't even tell you how many cases I've tried. I'm always leery of lawyers. I've tried X number of cases. Okay, that's your job. And that was my job as an assistant state's attorney. I tried cases, and I tried a lot of them. I've never had lawyers try to play discovery games in front of me as a judge. Oh, that never happens. It happens, okay? And I know what it is. When I see it, I recognize it, and I correct it. While my opponent, Tim, has advocated civil cases, I've actually presided over them. I've presided over personal injury cases. I've presided over medical malpractice cases, medical negligence. I've presided over business dispute cases. I've actually presided over them. And I believe I've received high praise from the lawyers that I presided, who have tried cases before me, that I've done a good job. I have been fair and knowledgeable of the law. I have that experience.
And I think I've presided over my share of cases, too. I've been acting as a city judge for 7 years, and I've heard evidence and had to make the same types of rulings. And to be fair, the rules of evidence are the same, but that's not the rules that I'm making reference to.
Tell us a little bit more about being your role over the city judge. What kind of cases were you involved in? That sort of nature.
Ordinance and zoning violations primarily.
Okay. So you weren't doing parking tickets. This was a little bit more.
No, I mean, this is situations where, the officers write tickets, and the people who have been ticketed come in and challenge the officer's basis for that.
Right.
Or the city inspecting officers cite conditions of property as being in violation of the code, and the people come in and argue that. So they present, whatever types of evidence are common, photographs, testimony, things of that nature.
And when did you start that? You said 7 years ago?
2006.
2006.
January.
And then how long have you been doing the thing for the state appellate prosecutor?
Since I first got out of law school in 1983.
And what does that entail?
That is, I handle briefs for the 4th District appellate area. So it's every state attorney who practices in that geographical region, which goes from Quincy to Bloomington to Danville to I don't know how far south, but it's quite a few counties. And what they do is, every criminal that's convicted wants to appeal. And so what you get to do is you read the entire transcript, and you benefit by understanding what mistakes the other side is alleging and what the judge has done. So it's quite an education because they're drawing your attention to those aspects of the trial that they believe were done in error, and you research the law and you determine or you argue, of course, for the state as to why the state was appropriate in behaving as they did. So I've written at least 400 briefs over that 30-year period of time.
And I don't need to, we'll get back to you, John, but I know that your ad campaign is all about how there's no political influence anywhere, but don't people who get jobs over there or get jobs with the city often know the politicians involved, or else you can't get those jobs?
Well, I don't know what you mean by that.
Well, I mean, like, I just looked up, you donated $500 to Davlin in 09 and 07, and another one here if I could read my own writing. I mean, you've been a part of the political process, and you have worked for city government and state government, which is part of the political process. And I know John has donated a lot to Republicans and has got a lot from Republicans, but aren't you, also a political animal in this town and in doing your job as well?
Well, I think the distinction I was trying to draw is that I haven't been the recipient of large sums of money. I believe that John's been a beneficiary of hundreds of thousands of dollars over his political career from people that are substantially politically motivated and influential people here in this community. I have not been in that position. I have never run for office. I have, never been a political candidate. And I don't believe in this instance, running for judge, that I've been the recipient of substantial sums of money from any particular individual or entity. Have I donated to other candidates in the past? Tim Davlin was a close personal friend. I've known him since I was born. Other candidates in the past, sure, I've given contributions to.
Yeah, well, and just to finish this thought, and then we'll get to John's response to some of this, but if I could, I'll get back to it in a second.
Sure.
Oh no, I know. Your latest ad says that, many of your ads are, I don't have any political influence, I don't know anybody anything, and then the other ad is you list about 10 unions that are supporting you, which I assume also comes with contributions. So aren't those kind of
those are different ads.
Purposes? I know, but don't they kind of conflict with one another?
Well, one points to my lack of obligations to political power individuals, and the other suggests who supports me in my candidacy for judge.
Don't unions have political power?
If they do, I don't know what are you suggesting that they have given me large sums of money?
Well, I don't know that, but
You can look on the Election Commission Board and determine that. If they are, it's unknown to me. But I don't believe that's the case. I think that there are large groups of individuals that support my candidacy, and that's why I think the advertisement is directed to show these are the types of people that have confidence in me, so should you, as opposed to the first commercial, which was attempting to say I don't have any association with political power bosses or any obligation to hold in favor of them.
John, obviously, in past campaigns also, you have received a lot of support.
There's a lot of response there.
Yeah.
Let's talk about the Appellate Prosecutor's Office first. Number one, the Appellate Prosecutor's Office is governed by a Board of Governors. It's the State's Attorney's Appellate Prosecutor's Office. And it's governed by a Board of Governors who are elected State's Attorneys. And those Board of Governors are elected from the State's Attorneys. So the State's Attorneys have an election, and they pick their members to run that board. And I was honored to be elected to that board for, I think, 8 years I was on that board. I was also honored to be chairman, to be selected by my peers, the state's attorneys, as chairman of that board. And every state's attorney that participates, the counties pay a fee, and they write the briefs that come out of the state's attorney's office. Please understand, in the state's attorney's office, if you had to pay someone to write the brief, you couldn't do it as economically as you could paying the state's attorney's appellate prosecutor's office. That's what they do. They also have a special prosecutions wing, which is a different branch of the office. But what Tim did is write briefs. What I did as a prosecutor is meet with people that had just had their loved one murdered. Meet with survivors of sexual assault. Meet with individuals that just lost a loved one to driving under the influence of alcohol. Meet with people that just had their homes burglarized and their lives turned upside down by some criminal act. I met them. I worked with the investigators. I developed the case. I developed the evidence, and I made the charging decisions. Quite frankly, as a prosecutor, that's probably your most important job, is your charging decision, because you're the only one that can do it. You're the only one can do it. Now, how does that translate to judicial experience? You're making those same decisions as a judge. You're gathering facts, you're looking at the evidence, and you're applying the law. Let me give you another example. I was asked several years ago to investigate whether or not Senator Roland Burris violated the law, whether or not he committed perjury. Now, I have to tell you, the public comments I received were overwhelmingly against Senator Burris. Statement says, you should indict him. You should charge him. I mean, I got letters to that effect. I got phone calls to that effect. And as I called it, my grocery store poll, people would say, aren't you the state's attorney? Many times I'm like, no, I look like him, but if he's here, I want to talk to him too. But you should indict him. Well, when you looked at the evidence that we gathered, when you looked at the law that was there was no grounds to indict him. There wasn't even enough evidence to put his case in front of the grand jury. And we discovered that, and that's what we did. That's what a judge does. You look at the evidence. Now, you don't gather it. That's a different part. You look at the evidence that's presented to you. You review the law, and you make a decision. Now, when you talk about experience as a state's attorney, yes, I am in the paper and the TV and the radio, or I was, for the criminal part of the job. But my experience didn't end there as state's attorney. Land use issues, employment issues. You're the chief legal counsel to the county. So employment issues came before us. Taxation issues came before us. I was part of the legal team that guided the merger between the city and county health departments. When the legislative body said that was going to happen, the county board and the city council, that took legal work. I was the state's attorney when that occurred. And we worked those agreements out. Contracts, requests for bids, all those things come before the state's attorney. It's much more than just a criminal prosecutor. Now, it's questions as to donations. I've been honored and pleased to have many people support me over my political career. Now, let's talk about that. I don't know if you want, somewhere we got politician is a bad word. Well, I've run for 2 offices in my political career. I've run for state's attorney. I won election in 2000. I won election in 2004, and I won election in 2008. Now, let's be fair. 2004, I didn't have an opponent, so hopefully my wife voted for me, but once I voted, I was going to win. All right? I understand that. But those are the only 2 offices I've run for, and circuit judge. And circuit judge. I've served 11 years as a state's attorney. So that's my experience as far as being a politician. I enjoy meeting people. I enjoy going to parades. I enjoy knocking on doors. Those are things politicians do. Money. I have been honored to have the support of many people throughout my political career, but money's never influenced or factored in my decision in any way, shape, or form, and I have a record to show that.
On another political question here, John, I mean, there's a seeming pattern of state's attorneys finding themselves being appointed judges, and then then the county board chooses, typically the first assistant or whomever from the prosecutor's office to take that role. It's happened multiple times. Can you address that? I mean, some people have a problem with that.
I understand that, and that's fine. But remember, the state's attorney and the judge will rise and fall on their own merits. Now, let's talk about my appointment. My appointment was an appointment from the Supreme Court. Justice Rita Garman recommended me to the Illinois Supreme Court, and the Illinois Supreme Court appointed me. Before I was appointed, though, I applied for the job. And I don't know if Tim applied for the job. I don't know who all applied. You have a record of that. But we met with a committee. All right? I was interviewed by a committee. In that committee, after I was interviewed by either the committee first or the Supreme Court justice first. But after we met with the committee, I believe we met with the Supreme Court justice, and she interviewed us. And after she accepted the recommendation of her committee, all right, I was appointed. It wasn't just this bam, bam, you're appointed. I went through the interview process. I sat and interviewed with the individuals. I sat and interviewed with the Supreme Court Justice. I believe when she appointed me, it was a rather emotional day. I remember that. I believe she told me I was the first choice of her committee.
Who was on the, I'm just curious, who was on that?
Sure. That's right. Mr. Bruner, Jim Bruner, who's a supporter of mine.
Yeah.
There's no question about that. John Knoll. Howard Peters Sr., the former director of Department of Human Services. Retired Judge Ron Robinson. And a lady from the, I knew I was going to forget her, Carolyn, I want to say Moore, another citizen from the community that lives in the Rochester area, I believe.
Okay.
Those are the individuals. So,
And then so Rita Garman had this committee, they recommended you, she appointed you.
yes, yes,
Jim Bruner was on the TRS with your dad.
yes.
And Tim, how many judges and lawyers or legislators were in your family?
5 currently that are alive. If you want to count my grandfathers and great uncles, we can expand that.
Yeah. Your father was a state rep, is that right?
He was a state representative for 6 or 8 years, and then he was a trial court judge and then an appellate court judge.
And my father also, I think my father had a more honorable job than a judge. He was a principal and a teacher. And so, I'm a judge, and Tim is an attorney because of teachers. My mom was a teacher until she had me in 1965. Then my father was a teacher at George Washington, at Athens School District, George Washington Middle School. He was principal of Staley Grade School, Palmer Elementary School, which no longer exists. It was in the middle of the John Hay homes. It's now the other apartments there. And he's principal of Lanphier High School. So he educated tens of thousands of children.
I asked Tim something about advertising, and I want to ask you too, John.
Mm-hmm.
You've got the sheriff advertising for you. He watched you put thousands of criminals away behind bars.
Mm-hmm.
Doesn't having the sheriff advertise for you make it look like you're biased against the criminal when they come to your court?
No, because the sheriff's job isn't to arrest people. The sheriff's job is to gather evidence and present it to the state's attorney, or to gather evidence and see that it goes nowhere and close the case. That's the sheriff's job, and this sheriff has done a good job of that over his tenure.
Thoughts on that stuff, Tim? This
Yeah,
whole law and order thing?
and that's really goes back to what I'm talking about. I mean, the breadth of my experience, I think, is what makes me the better candidate. John's entire career has been as a state's attorney. That's the only thing he's done in his career. I've represented both sides. I've represented defendants who have been charged with crimes in both the state and federal courts, and I've prosecuted them as well. I worked for the state's attorney's office for a short period of time in Bill Roberts' office, and as John indicated, I've written briefs on support of them as well. And so I understand that, both sides of the fence. And I think if you do one thing only, and you do that exclusively, you can't help but be a little jaded and biased by your experiences in that position. If you work both sides of the table, you understand, what the other side is dealing with, the other side suffers with, how injustices can be done, how people can be wrongfully accused of things, and how they suffer with that. So I think that gives me a really good insight. And that's, when John talks about the things that he has done as state's attorney that could be defined as civil work, again, that's not really what I'm making reference to in an attempt to try to distinguish my experience. I'm talking about courtroom experience. I'm talking about actually being in a courtroom, and that, I think, is what prepares you to be a good judge.
Well, are you saying that you would rather be hearing civil cases if you get to the bench over there, or will you handle criminal cases in any way different than the judges there now handle them, or would you have a different emphasis?
In the criminal situation, probably not. In the civil, perhaps. I can give you examples of where I think judges in the past have made errant decisions because they don't understand what the attorneys are attempting to do by way of motion to prohibit or motion to exclude. If you don't have...
Okay, give an example.
All right. I was in In a trial last fall, acting as local counsel in a professional malpractice suit where the issue was whether or not the treating physician was going to be allowed to use a CAT scan as evidence. When his deposition was taken 2 years prior to trial, the attorney requesting the dep requested that he bring copies of everything, which is traditional. That's what they do. Bring everything you got. When you get to the dep, traditionally the doctor has nothing because everything's on electronic format these days, and they don't take the test, so they really don't have hard copies of the test. Nevertheless, the entire deposition focused around the CAT scan. That was critical to the case. So we get to trial, and on the day of trial, opposing counsel files a 15-page memorandum as to why the doctor's testimony should be stricken or limited, and that the CAT scan test should not be introduced because it wasn't presented at this deposition. Now, the law does state that if there's a request for these documents and they're not produced by the party offering the witness, that there's a sanction to be imposed because they don't want, you're not to withhold evidence from the other side and then throw it out at trial. Nobody's surprised. You should know everything long before the trial date. But in this instance, the judge, did limit the introduction of that CAT scan because he didn't understand that, that was just a setup by the opposing counsel. He had no intention of really wanting the CAT scan. He knew the CAT scan wasn't going to help his side of the case. And the judge mistakenly applied that sanction, prohibited the introduction of that because he didn't understand that the gamesmanship, basically, that's being played there.
Which judge?
Not going to do that.
Won't say the case or the judge.
Nope.
Any thoughts, John, just on?
I don't have enough facts before me. I know the law in that case. I know what the law is and how to follow the law, but no.
What's the toughest case you guys have ever either tried or in your case, had to be a judge on?
Well, I have both. I mean,
Okay.
toughest case,
Yeah, go ahead.
any sentencing's tough. Any sentencing's tough. You're in a courtroom because something bad's happened already. I mean, someone's been harmed and someone is coming to justice for it. And I'm not saying that's a bad thing, but it's not a celebratory thing. So as a judge, sentencings are difficult because those are human beings. And, you see people like, well, I'd love to be a judge because I'd give them X number of years. Well, you don't understand what it is to be a judge. I mean, we get paid to give thoughtful consideration to both sides. And that means giving thoughtful consideration to both sides, listening to the evidence in aggravation and mitigation. So sentencings are tough as a judge.
Is there one in particular that was tougher than the others then?
No, I mean, because you're affecting that individual.
Yeah.
I mean, you're affecting that individual, and that is, and you look them in the eye when you do it. So those are tough days. They're done, but you don't go home and jump up and down. As a lawyer, as a prosecutor years ago, I tried back then it was called reckless homicide, of a young man by the name of Nix. And I can't remember the defendant's name. But Mr. Nix was, car or truck was stalled, and he was pushing his truck. And the defendant hit him from behind at highway speeds. And it took his life. He was killed. And the driver was, back then it was I think it was we were still .10. He was hundredths over the limit. So you're fighting the spiking argument. And we had a breath test, that's all we had. But the real issue of the case came down to the recklessness issue also. And was it the alcohol that caused the driving? Or was it the fact that the defendant couldn't see the victim because he was covering the taillight with his body? And I remember they came back not.
Was it dark or something?
Yeah, I'm sorry. Yeah, it was in the middle of the night. They came back not guilty. And you're disappointed, obviously, as a prosecutor. I believe we had sufficient evidence, but you certainly accept the verdict. I remember the jurors came back and spoke. I didn't ask to speak to them. They came back and spoke to me. And they said that we believed the case just was not quite reasonable doubt. We sat together, and they said we sat together and we each prayed that we'd come to the correct decision and return the verdict. And they did, because anytime a jury returns a verdict, justice is done. You might not agree with it, but justice is done. That was a tough case. Speaking to the family afterwards is difficult. They also understood the verdict, but it doesn't make it any easier. So I think that'd be that one sticks out in my mind. I rarely talk about it, but that one sticks out in my mind.
Tim?
I don't know that I have a particular case. I can echo John's concerns. That's part of the reason I like arguing the state cases, because I feel like when a jury comes back and renders a decision, you're not in it to win or lose as a prosecutor. Your competitive nature takes over, and if you charged the guy with a crime and brought him through a trial, you better think he's guilty. So I understand that aspect of it. But if the jury doesn't agree with you, then justice has been done, and there's no reason to be upset about that. So long as you've done your job as a prosecutor, I think you should be happy with that. I was representing a gal, though, in federal court who was charged with production and distribution of methamphetamine, which at that time carried a mandatory minimum sentence of 5 years. She had a small child. She's about 26 years of age, and this was basically going to ruin her life. She was scared to death, and they charged her along with 4 others at the time. So I was trying the case with 4 other lawyers. And it was, I was a relatively young lawyer at the time. I think I had about 7-8 years experience. And it was just the fact that this young lady was so petrified of the potential results of this trial, and that it meant so much to you. I mean, her future rose and fall with my ability to convince the jury of the weakness of the government's case. And if you've ever tried a case in federal court, it's pretty difficult to do. Those guys have a great many, those guys being the United States attorneys, have a great many tools at their disposal. And they usually don't indict people unless they've got a very strong case. We were fortunate to win that case. And when the jury came back and exonerated her, it was like the sword of Damocles being removed from her head, or a huge weight off her shoulders. Not only hers, but mine. It was during Thanksgiving, and that will always stand in my mind. I was waiting for the jury to come back with its verdict the night before Thanksgiving, and I couldn't relax either until that verdict was finally given. But in a civil sense, I've represented so many people that have been hurt by catastrophic injuries. Probably the one that stands out the most is a guy who lost his wife, his 12-year-old daughter, and his 14-year-old daughter was fairly severely injured riding in the back seat when a trailer became unhitched from a half-ton, full-ton pickup, crossed the center line and slammed into this vehicle, instantly killing the wife and daughter who were riding in the front seat and injuring the 2 in the back. We brought an action against the manufacturer of the hitch, the owner of the trailer, the inspector of the trailer and hitch, and we were ultimately successful on that. I mean, it was very complicated, a multitude of lawyers involved. You had to sue the manufacturer, so that brought in a great many corporate entities. So it was a very protracted piece of litigation, and we were able to get some sense of security for what was left of that man's family. That stands out, I think, just because of the complexity and all the things that were involved in that case and its ultimate success. As a judge, what strikes me is no one particular case, but it's always difficult to look somebody in the eye that says, I didn't do it. What the officer is telling you is not true. You have to believe me. I'm being honest with you. That's just not the case. And you have the officer looking you in the eye saying exactly the opposite. I pulled the guy over. This is what he did. He's guilty of the crime that I'm alleged that he committed. And you have to tell the people, that on balance of evidence, if this is going to work, they have to have more than their word. You know, that you hate to tell people that they're liars, and I don't. You don't suggest that they're not telling you the truth, but obviously it's one or the other. You have to make a decision, and you weren't there, and you don't know who's lying to you and who's not. Generally, you're going to come down on the side of the police officer because that's what he's employed to do. He's in uniform, he's out there, and the system isn't going to work if you require 2, 3, 4. I mean, if you're not going to believe one police officer, you're going to believe 2. If 2 can be in cahoots, then are you going to require 3? And it just, if it's going to work, you have to think that the officer is going to be honest in his recollection of events unless you have some independent reason to think otherwise. And that's what you try to explain to the defendant and try to get them to understand. They have to, you know, their burden of proof is more than simply, I didn't do it. But it's hard. It's hard to look people in the eye and have to suggest to them that you have to hold against them because they feel like you're calling them a liar or that you don't believe their version of events. And surely anytime you impose a fine, I mean, it doesn't matter what it is. You can put a guy in jail for the rest of his life. You can tell somebody that that's a $1,000 fine and they say, I haven't got $1,000. You know, I'm on welfare. I don't have any money. I can't get my car out of hock. You know, they're pleading with you to set the law aside because of their particular situation. And it's hard to apply the law always as it is, but, you know, that's our job.
That must be a different court because in the courtroom I sit in, the defendant doesn't have a burden of proof. They're presumed innocent.
Yeah, that's what I meant.
And it's the state's burden to come forward with the evidence and convince the judge or the jury, be it a traffic ticket or first-degree murder, that the state has to prove to the judge or jury that their evidence has proven the defendant guilty beyond a reasonable doubt. And that's the standard I apply.
Of course, that's the standard everyone applies. And if you interpreted my comments as being anything other than that, then I apologize and I'll correct that. Obviously, what John had stated is true. Perhaps my choice of words were not appropriate or totally correct, but what I was attempting to convey is that you're going to have to, if you're the defendant and the state has met its burden by a reasonable doubt, you know, it's tough to tell those people that you're going to rule against them because they're decent people. You know, just because they've committed a crime or they've done something in violation of the law doesn't make them bad individuals.
Tim, I wanted to clarify something. I'm just not clear on it. But your work with the appellate prosecutor's office, do you actually appear in court to present these briefs, or do you write them and one of their attorneys does it, or how does that work?
I appear at appellate court.
Okay.
And that's part of the reason why I have so many appellate court arguments. But many of them are from my private work as well.
Okay.
You know, now that you mention, you know, just the private work, I think that's another benefit that I enjoy. I mean, not only do I have civil litigation experience, but I'm in private practice. I've run my own business. You know, I don't derive all of my money from the taxpayers. I've not only been a practicing attorney, but I've had my own title company. I have my own trucking company. I've been a private businessman, and I think that gives me experience that my opponent lacks.
What happens to the trucking, what trucking company is it?
It's called Rising Star Leasing, still in existence.
What happens to that if you get elected judge? Can you still have that on the side?
You know, I think I either have to divest myself of that or put it in some type of blind trust or something of that nature. I'm not totally sure about that, Bernie, but if that happens, I'll have to investigate it.
Okay. And with your ad campaign of there's no influence on me, are you saying that any influence or contributions or anything has affected any cases John has handled?
Well, I can't speak for John. I mean, I'm not in a position to make that determination. I would hope not, but obviously I think it raises a question. You know, he's been in that system. He's been the recipient of that type of money. I think the people that give those types of money probably expect something in return. Whether or not they get it, I have no idea.
I think you already said.
No, absolutely not. I mean,
Yeah.
I said this, you know, time and time again. I'm always honored by the support I have, but it doesn't affect me and it doesn't affect how I will rule. And I have a track record of that.
I know this is a difficult case, but it's certainly one that's out there, and I appreciate your calling me back so readily last week about the Catholic Charities case that you ruled on. Your thoughts on this Illinois Family Institute and even the bishop of the Springfield Diocese being critical of the decision that you made in court on the Catholic Charities?
Well, as I said to you, Bernie, that night, judges follow the law. That's what we do. We don't make decisions with our finger, our political finger, our sentimental finger, the wind finger in the air. We make the decisions based upon the facts and the law, and that's what I do, and that's what I did in that case. I don't make decisions based upon whether someone, be it a bishop or be it another individual, that is going to disagree or agree with me. I don't do that. If you just can't. If you do that, the judicial system crumbles. It fails. And that's just not going to happen. Not on my watch. And judges, I said also to you, judges and bishops have different jobs. I respect the bishop. I respect his opinion. I'm able to read his opinion and think about it. But we have different jobs. And I believe he respects mine too. I really do. I put my opinion out there. The paper has a copy of it. I can't comment much farther than that. But I put it out there for critical analysis. And that's what judges do. Parenthetically, I just say, I think they dropped the appeal. I'm not the court of last resort on that case. They could have appealed, and I believe the appeal was dropped. So I don't know what advice they got, but my opinion stands, and I followed the law.
How would you like to inject yourself into this instruction?
Well, first of all, it'd be unprofessional for me to try to comment on a case that I didn't hear any evidence about, nor have I investigated the law applicable to it. Also, it would be in violation of the canons of ethics, as I understand them. The judicial board prohibits me from giving opinions on any issue that might come before me, so I don't think I can comment directly on it. I would say, though, that I think John gives a simplistic answer to a very involved and complicated question. Sitting as a judge is much more than hearing the evidence and applying the law. If it was that easy, we could probably have some computer do it for us. The world isn't made up of black and white. The world is made up of infinite shades of gray, and that's why you need a judge, and that's why a judge's experience is so important. You are called upon to make judgment calls constantly, and that's why you need someone that has the experience in life to put them in a position to do that.
Quick question on sentencing, because I heard both of you on one of your radio interviews, and John, you said something about you want to take a look at the totality of what the person has made of his life. Tell me if I'm wrong about that. Give me a little sentencing philosophy, and I know Mr. Leach raised a question or something about that afterwards.
No, I understand. No, it is, you have to look at an individual. I mean, have they committed crime all their life? Have they lived a life of crime? Or is this an aberration? Or is this a first offense? Is this a second offense? That's what I'm talking about. How they've lived their life and what they've done with their life. That's important when you stand before a judge. You're certainly entitled to argue it to the judge, that I've lived a good life. I've done X, Y, and Z. And for me as a judge to say, well, I'm just not going to listen to that, would be wrong.
And sentencing philosophy?
Well, I think that's probably the most important thing you look at is the individual and the circumstances around the crime. I would assume that, I won't assume. Did he plead guilty to the offense or was he found guilty? Does he have a history of this type of thing? Is it a violent offense? Anyone that commits a violent act against another, I think, brings themselves outside of society's most basic rules. And I think they need to be dealt with more harshly. However, it depends is always the answer. There's so many factors, and as John's indicated, I think in the past, there's certain statutory factors you're supposed to hear in mitigation and aggravation. And again, you have to rely upon your experience in life, in judging people and getting a feel for whether or not this person is rehabilitatable or whether or not they possess a threat or are a threat to society if they're allowed to remain in it.
And I know both of you, I think, have been supporting cameras, which we have not yet seen in active cameras in the courtroom and trial courts in Sangamon County. But both of you gung-ho on that idea, or how do you feel about that idea?
I'm all for it. I'm kind of saddened that Whiteside County got it before us. Whiteside County just did it. I see on an article in the Chicago Tribune. I see they had trouble with humming feedback on the central feed. I've given a great deal of thought to cameras in the courtroom. It's up to the chief judge to petition the Supreme Court to initiate the program. I'll gladly volunteer. That they do that, I'll gladly take the lead and get the process moving. I've actually given it thought about what needs to be done, who needs to come to the table, who needs to meet, what we need to do. I've actually thought about that, and I'm ready to do that. It's certainly a good idea. Like I said, we take pride in this area as being the home of Lincoln. So a trendsetter and trailblazer himself, I think I'd like to see us continue that.
And are you worried at all about the grandstanding argument?
I've never,
et cetera.
I've seen so many lawyers. I just don't. That argument is very hollow with me. Plus, if you let lawyers do that as a judge, you've lost control of the courtroom. You don't have to be mean, but you can certainly set the tone. That's the judge's job. And the first thing when they walk in is set the tone. This is what we're going to do. We're here to conduct business, and this is how we're going to do it. And so, if you let the lawyers, you've lost control. You probably ought to reevaluate your own performance in that case.
Lawyers are already grandstanding. I mean, it's not going to be anything new. I mean, any lawyer that's paying attention to the camera or the people behind him has probably already lost the case. The most important people are those in the jury. And yeah, you know they're there every second they're there. That's your job. And you're always doing what you can to make yourself a credible individual. Some guys like to grandstand, flash, whatever, that's their style. So you're never going to change that. And courtrooms or cameras in the courtroom, I think are very helpful to allow the rest of society to understand what's really going on over there. Anytime you can be more transparent, I think you're better off. And I'm really tired of the Judge Judy shows and all these things that give these guys a false impression of what justice is about. I mean, these shows may be entertaining, but they really don't do a very good job of educating people. In fact, they do just the opposite. People walk away with a false impression of what's really going on. So I think it is important to have cameras in the courtroom, but we have to be careful. This is a new program. It has not been implemented yet. There's always going to be potential problems with it, and there's people that need protection. John was mentioning, I think in an argument that we had, debate, whatever, about a green dot being on one of the witnesses' faces and how terrible that was. Well, probably, or could be, but if that witness did not wish to be identified because she was the victim of some sexual assault, I can understand why she would prefer to have a green dot on her face. If there's jurors that feel as though there may be repercussions, if they're shown on camera, putting Guido in jail, I think that's something we have to consider. So, there are a lot of considerations, and I'm sure the Supreme Court has dutifully considered these. But with every new program, you got to work the bugs out. So, yes, I'm in favor of it, but with a little caution.
I'll bet you want to respond to that.
There's a blue dot. It was a William Kennedy Smith trial, and the rules are written prevent that. They stop that type of thing from happening. They give
the new Illinois.
Yes, the Illinois Supreme Court rules. They give a modicum of dignity. Ultimately, they give the trial judge the on-off switch, and you're giving the referee the button, and that's good. That's good. But so that's what I was talking about. You're allowed to adjust your camera views to prevent them from even being shown. Maybe just the audio is. The jurors are never shown, identified by name or anything like that. All that is thought out in the rules, every last part of it. As far as working the bugs out, I understand that. But the Supreme Court, our Supreme Court, state Supreme Court, has said this is to happen. There's going to be bugs the first time you do anything. And quite frankly, my philosophy is I'd rather be the one working them out. It's maybe a bad stain, a little hackneyed, but unless you're in the lead, the view doesn't change. I'd rather be the one working them out. I believe we can, collectively, because this is a collective effort under the rules, I mean, the courts, the media, there's a local feed, all this can fix that and overcome it so we can make it true. My wife, she's gonna watch this and kill me. She's like, don't get too excited about that. But it's something to be excited about because it's really a change and it's a one for the better.
Speaking of change, could I ask you a question to each of you? I looked up your ABA ratings, and you're pretty comparable in most areas in terms of that. So to distinguish on a party basis is probably not a good thing either. I don't know whether a party label has any meaning in a judicial race or doesn't.
I think the answer is yes and no. To some people, a party label does. There are some people that are going to come vote for me no matter what. There are some people that come vote for Tim no matter what because of a party label.
But I guess what I'm asking is, in your mind, are there principles associated with your political affiliation?
Absolutely not.
No,
I don't know
absolutely
why
not.
we're running on a party
No.
label. It probably should be a nonpartisan type of situation because, I've had this question put to me, what political philosophy are you going to take to the bench? None. I'm running on a Democratic Party's label, but, I bring my experiences in life to the bench, but I don't bring a party philosophy. And if you do, I don't think you're doing your job as a judge.
Well, if you look at the Supreme Court, there appears to be a lot of division along party lines, and you're saying that doesn't happen in local government.
It's not happening with me. I mean, I'm not bringing any political philosophy to the bench. I'm bringing my experience, my legal experience, my wife's experience to the bench. That's what I bring. All right? I might be as fat as an elephant, but I'm not an elephant sitting up there. Okay? I'm John Schmidt. Here's my body of work. Here's my experience. Here's what I've done. That's what I bring.
Are there reforms then that you believe would enhance the quality of life and bring us closer to our democratic ideals in the judicial system and the criminal justice system?
But, the problem. This was brought up to us in Jacksonville. The problem is age old. The problem is age old. I think the solution is individual. You have to look at the individuals and see where they stand and what they do. And I think it becomes readily apparent when you talk about limiting campaign donations. The U.S. Supreme Court has spoken out about that in Citizens United, that we can't do that. The state Supreme Court and our rules of conduct has put in protections. We have to form committees to raise money. Neither one of us knows who's given us money. All right? We have to have Tim has a committee, I have a committee. And the Supreme Court also has the rules that if you believe because of any reason, be it a donation, be it you know them, be it you like them too much, or be it you don't care for them, if someone comes before you, you have to recuse yourself at any time and say, I cannot hear this case, I recuse myself, I reassign it. So there are protections in place.
Which is kind of an oxymoron because you're not supposed to know the guy gave you money, so how do you know to recuse yourself from it? And if everybody that gives you money is posted on the Election Commission's website identifying them as giving you money, how can you not know who gave you money? I mean, everybody else knows who gave you money, but apparently the judge or the candidate is not supposed to know that. There's some problems with that. Obviously, the Supreme Court is pretty political. They make policy, and therefore, there's been a lot of money spent on Supreme Court races, and I think that draws into question why. What are people hoping to gain by that? Is it really good government? Are you giving somebody $2 million because you have a keen interest in good government, or are you hoping for a return on your investment? That's the point that I was making before. I think John is a political animal. I think that's, if you want to run for office 3 times as the state's attorney, I think that you have to take the baggage that comes with that. A lot of people have given him money. I think he has made decisions as state's attorney that could be politically motivated. He gets to decide who's prosecuted and who's not, who's investigated and who's not. I don't have evidence because you can't have evidence. Unless you're in John's mind, you never know exactly what it is that motivated this or that, but there seems to be a lot of activity going on in this area that was or was not investigated. The last 2 governors went to jail, and a lot of people that supported those governors went to jail with them. But nothing was ever done in Sangamon County to investigate any of those. And I don't know what the reasons for that could be. But,
Well, there's a simple answer to that. The U.S. Attorney in the Northern District of Illinois, they investigated those cases, and that's why those individuals are in jail. It's not because I didn't do something as a state's attorney.
just saying they weren't investigated down here. And I don't know the reasons for that, but, I mean, that's the perception. And I think that's the advantage of not coming from that system. I haven't been a political entity, I haven't been a political animal, I've never run for office. So I think I don't have that baggage.
Tim, you just said that you think John was influenced by the support he received. Are you just saying because there wasn't white-collar crime or governmental crime prosecuted as much as you would have liked, or is there a particular case that you're talking about where you think the influence showed itself?
No, I'm just saying that in the capacity of state's attorney, you obviously have a great deal of influence as to who's charged and who's not.
And was there some case that you know of where somebody should have been charged where they were not?
No.
With that, do we have any other questions? All right, gentlemen, thank you for coming in.
Thank you.
Thank you.